Welcome, everyone, to our fourth webinar in the webinar series of Conversation in Context in Working Group 1, Keith Ritia's Course Action. Today, we've got Dr. Kim Tao-Lee from Université Paris-Nanterre, Chad, and she is actually a long-term collaborator who's going really to elaborate on a very interesting historical insight related to culture expertise. Dr. Kim, dealing with an issue addressed as before expert witnessing, early sensibilities of cultural expertise in medieval English law. You are welcome to our webinar series. Please.
Thank you very much, Dina. Thank you very much for the invitation, and thank you all for joining us today. So it is a real pleasure to speak within the Caperisha network, especially knowing that many of you work directly with cultural expertise in contemporary legal settings. So first, I would like to begin with a very small vignette from a medieval court record, precisely in 13th century in England, because it captures in miniature the problem I want to discuss with you today. So in a 13th century entry, a man kills another during a quarrel in a tavern. The record moves quickly through what matters legally. He fled immediately. He is treated as suspected. He is exacted, meaning he is put in exigent, and eventually outlawed for non-appearance in court. And then on the record, the clerk adds two details that are not about the violent act itself. It is said that the man had no chattels and he was not in a tithing, which is a communal responsibility unit, because he was a stranger. And that combination is unusually revealing. So this record shows a legal word in which courts are not simply asking what happened, but also how should this conduct be read. In this setting, by this kind of person, with these social ties or without them. This is why I would like to bring my contribution as a medieval legal historian. We often assume that expertise becomes relevant to courts only once expert witnesses formally appear. When expertise is named, regulated, and institutionalized. My work starts earlier, 12th and 13th centuries, the early years of common law in England. I am interested in what happens before expert witnessing exists, when courts still have to decide difficult cases under uncertainty, but without expert testimony, without a stabilized doctrine of evidence or any formal doctrine of evidence, and without modern categories of proof, of course. So to be clear, I am not claiming that medieval jurors were cultural experts, and I am not historicizing contemporary cultural expertise as such. What I would like to explore instead is a recurring problem that I think will sound familiar to you. How courts make socially embedded knowledge legally operative when they cannot rely on technical expertise. And that framing question is what the next slide makes explicit. So this slide sets up the core question of the talk. And I want to be clear about that. The question I am asking is a deliberately simple one. How the courts decide cases when they had to decide, but did not yet have expert witnesses, forensic evidence, or a formal doctrine of proof, as I said. So, medieval English courts faced that situation routinely. Serious criminal cases had to be resolved, often with partial information, conflicting accounts, and no authoritative technical knowledge to rely on. My argument is that they did not resolve this uncertainty by waiting for better proof, but by mobilizing socially embedded knowledge. Things like reputation, local memory, shared expectations of how people behave in moments of crisis, for instance, and systems of communal accountability. And in England, that work was done primarily by juries. By juries here, I do not mean modern trial juries. I mean medieval jurors that are groups of local men sworn and summoned from the neighborhood whose authority rested on their familiarity with the people, places, and social norms involved. So what interested me is the material, what the materials reveals about a recurring adjudicative problem. How legal systems transform contextual, unevenly distributed social knowledge into decisions that are legally binding. So this is a legal historical case study, but the ambition is broader. I use medieval material to illuminate a problem that remains very much alive today, namely how courts integrate context into judgment without collapsing into arbitrariness or bias. So, to understand why this problem becomes especially visible in medieval England, we need to start with a moment of procedural disruption, the disappearance of ordeal. But first, I'd like to give you the roadmap for the talk. So first, I will situate the argument in the early 13th century moment of procedural disruption, when the ordeal ceases to function as the routine mechanism of closure in felony cases. Second, I will explain why jurors become indispensable decision makers, not because they are experts, but because royal justice can mobilize their embedded local competence to reach decisions when certainty is unavailable. And third, I will show what jurors actually evaluate in practice. Not proof in a technical sense, but behavioral sequences and plausibility. Who raised the alarm, who fled, who stayed, how quickly help was summoned, and whether the story holds within locally shared expectation. And then fourth, I will turn to reputation, a so-called pharma, not as standalone proof, and not quite as a formal procedural trigger in the English way. It can be in Romano-canonical system as well, but as reputation as a contextual frame that stabilizes meaning and sometimes hardens bias. And finally, I will draw a cautious resonance with cultural expertise as theorized within Caperitia. So this distinction as as mentioned in Lydia Holden's work, will be helpful to clarify what medieval jurors were and were not doing. So now let's move to the procedural rupture. 1215. So what I mean by rupture, it was historically both abrupt in effect, but in practice it was gradual. Until the early 13th century, English felony procedure operates through a structure that relies on the ordeal for closure. So community accusation through presentment juries, which were accusation juries, established that after Henry's the second reforms, established that they had to identify suspect, and final resolution was often supplied by ordeal. Very briefly, the ordeal is a ritualized form of divine judgment. So the accused is subjected to a physical test, most commonly carrying hot iron or being immersed in water, and the outcome is interpreted as God's verdict on guilt or innocence. So what matters for my argument is not the ritual itself, but its procedural function. The ordeal is not evidence in the modern sense, of course, but it is a tool of closure. It allows the medieval systems to earn a certainty without articulating a theory of proof. And after 1215, clerical participation in the ordeal becomes unavailable following the Fourth Lateran Council. And so the effect was profound. Courts continued to prosecute felony, but the familiar terminal mechanism of divine proof can no longer be used routinely. And crucially, no formal evidentiary doctrine replaces it. There was no forensic regime, no police apparatus, no institution of expert witnesses. And what this produces was an epistemic problem that many of you will recognize. How do you reach binding legal outcomes under conditions of uncertainty, partial knowledge, or uneven information? And the answer in England during the Middle Ages was not procedural escalation, but was human interpretation and, above all, collective interpretation. And that is where the jury becomes central in the 12th century in England. So why jurors? Why exactly are they in this period? So first, two anachronisms need to be avoided. First, jurors are not simply witnesses. They may include people with direct knowledge, but the defining feature is not eyewitnessing or witnessing. Secondly, jurors, medieval jurors, were not experts in a modern professional sense. They had no specialized credentials and were not introduced as a separate epistemic authority. But what made jurors valuable is embeddedness. They were men of the locality, summoned from the vicinage, and sworn to speak within the social world in which the events occurred. So their authority rested on the assumption that proximity generates a kind of competence. familiarity with local reputations and conflicts, knowledge of who belongs to which accountability structures, awareness of ordinary patterns of behavior, and the ability to judge whether a narrative fits. And this is where the stranger, which who is not in the typing, so the communal responsibility unit, detail becomes structurally central rather than anecdotal. In a system organized through mutual surety, so the typings, the Frank Pledge system, belonging is not merely social, it is procedural. It shapes credibility, accountability, and the capacity to answer. Jurors thus function as a mechanism that translates neighborhood knowledge into outcomes the Crown can act upon. And this is also where Livia Holden's work becomes analytically helpful. Jurors can be called mediators only in a very limited sense. They stand between community knowledge and legal form, translating reputations, local memory, and shared expectations into a verdict the Crown can act upon. But they are not mediators in the sense of facilitating agreement or compromise. They are not managing a dispute between parties. They are producing a binding adjudicative outcome within a coercive legal process by interpreting conduct through locally shared meanings. And that distinction matters here for us because it highlights a broader point even in the absence of named experts. Adjudication can depend deeply on culturally embedded interpretation. So, what then do jurors actually evaluate? The medieval records show that medieval jurors rarely focus on isolated facts. Instead, they will construct sequences of behavior designed to make a death legally intelligible. They repeatedly attend to flight or remaining, raising or failing to raise the hue and cry, that is the legally expected communal alarm after a serious offense. They attend to delay or silence, possession and proximity, social placement, and accountability. So all these elements function cumulatively. One cue alone rarely determines an outcome. So what matters is whether the sequence forms a plausible account within shared expectation. This is why plausibility, rather than proof, is the operative logic for these medieval jurors. Jurors ask, does this story make sense locally, given what we know about how people behave when innocent, frightened, or guilty? Reputation enters here not as a proof, but as an interpretative frame. The same behavior can look like shock in one person and evasion in another. And this interpretative power is effective, but normatively dangerous. Indeed, it can convert social illegibility into legal vulnerability. So, it is important to underline that there is no graded and evidentiary system at work here. Jurors are not weighing probative value in a technical sense. They were asking whether an account was coherent with shared expectations of conduct and legal truth emerge from narrative coherence, not from evidentiary threshold. And this helps explain why formula like he fled and he was suspected appears very frequently in the records. They were not legal rules. They were compressed expression of a practical expectation. Innocence is imagined as social availability that is staying, answering, and being locatable. Again, this logic is powerful, but it is also uneven in its effects. So, reputation, it needs to be handled so carefully because in England, reputation does not operate as a self-standing evidentiary doctrine. In England, it conditions interpretations, it stabilizes meaning. Positive reputation can make suspicion implausible, and negative reputation can amplify ambiguity. And what matters analytically is not that reputation proves anything, but that it frames how conduct is read. And this is why reputation functions best as what we might call credibility infrastructure. So, this brings us to the more structural point. Belonging to a thieving or a front page system, so the surety unit, offered procedural protection for people. It provided sureties, reputational capital, and narrative stabilizers. Strangers lack these resources. Their conduct was harder to contextualize, harder to excuse, and easier to suspect. This is not incidental, it is systemic. So the legal system in the Middle Ages manages certainty asymmetrically. Insiders benefit from interpretive charity, and outsiders face accelerated suspicion and exclusion. The medieval jury thus distribute vulnerability unevenly, not because of malice, but because how context is operationalized. And so, this is where I return to Carpe Pizza and today. So, as a historian, I am proposing a resonance. Medieval jurors in England are not experts, but they exercise distributed interpretive authority. They translated socially embedded knowledge into legally binding outcomes. And here, Livia Holden distinction help us because it distinguishes mediation from adjudicative expertise. Medieval jurors do not mediate disputes, they interpret meaning within adjudication. And this allow us to see cultural expertise as a mode of legal reasoning. The medieval case makes a familiar dilemma unusually visible. Courts need context to decide, but context is never neutral. The trade-off between plausibility and bias, between understanding and exclusion is not new. And the medieval jurors shows what happens when culturally embedded interpretation is indispensable, but weakly constrained. That historical perspective can sharpen contemporary debates about safeguards, accountability, and the limits of contextual reasoning. So, in one sentence, medieval juries show how law can operate without experts, yet rely heavily on interpretation. This enabled closure but distributed vulnerability unevenly. Thank you very much.